All right, so good evening. Thanks to those of you who are joining live. I appreciate it. And those of you who are watching the recording, I appreciate it as well. Welcome to our workshop on holding government accountable. Let's go ahead and describe the workshop, and then we'll jump to our workshop for this week. So this workshop is a series that's focused on how individuals inside and outside of government can hold it accountable to the Constitution, federal and state laws, and regulations. This is a series of 16 30-minute workshops during the spring of 2022. They're held every Wednesday from 7:30 to 8, starting a little later today because my son was looking for the television remote. As I mentioned earlier, we try to hide it from him. And this obviously is held via Zoom. So we've discussed a range of topics over the past couple of months now, from student power to the state capitol to there's a manual to holding the president accountable to democratic accountability. And today we'll be discussing interaction between the state and the federal government to demonstrate the complexity of the relationship and how states can hold the federal government accountable and how the federal government can hold states accountable. So largely this interaction between governments. And as always, there's news articles you can check out from various sources like Politico, The Hill, Roll Call, Rough and Tumble, and so on. So let me just exit the slideshow really quick and jump us to our workshop for this week. So week 12, can you believe it? Slowly and steadily, we're almost at the end of the semester, about a month out. So today, again, we'll be talking about the interaction between state and federal government. So our learning objectives with this workshop are the following. First is to define federalisms. And secondly is to explain how the federal government and state governments interact with each other. So what are some of these federalisms that I'm talking about? Well, federalism is basically this sharing of power between the federal government here in the United States and the various state governments throughout the country. And that sharing of power has evolved over time. As you can imagine, we didn't have all 50 states at the beginning of the founding of this country, but now we do. We hadn't had robust economy at the start of this country. Now we do. We hadn't had robust transportation, communications, technological networks. Now we do. And so given all these broader economic, social, political, cultural, technological changes, the nature of sharing power between the federal government and the state government has evolved. So there are a couple of specific examples of federalism. So the first one is called cooperative federalism. And this essentially was born of necessity and lasted well into the 20th century as the national state governments each found it beneficial to work together. Under this model, both levels of governments coordinated their actions to solve national problems such as the Great Depression and the civil rights struggle of the following decades. What we see now in more recent time is a new federalism, which is premised on the idea that decentralization of policies enhances administrative efficiency and reduces the overall public spending and improves policy outcomes. Now, knowing that there's this power sharing between the federal and the state government, we can view this through the lens of holding government accountable because the federal government will take actions that might be viewed as infringing upon either state power or on individual power. And the state government can react to that in multiple ways, either by using itself as a laboratory of what we call democracy to enact policies that are maybe different from the preferences of the federal government, to suing the federal government in federal court on a range of issues. The reverse is also true, where the federal government obviously has some preferences for policies, and it can enact policies at the federal level, which might preempt or stop a state from implementing a law that goes against federal laws. The federal government can also sue states in federal court if they feel like the state is going over its bounds with respect to its delineated or non-delineated power within the Constitution. So essentially, we have different federalisms that have evolved over time, and that nature of the relationship between the federal and the state government is dynamic and continues to evolve even now. And we'll look at some examples to explore this further. So just to kind of give you a visualization also, because it's approaching past dinner time, so maybe you're thinking of having dessert. So cooperative federalism versus new federalism. So in the past, we had what we called layer cake federalism, which is that there's clear authorities between the state government and the federal governments and the local governments. So everyone knows their level of the cake. What we have today is what we call marble cake federalism, which we have like a mixing of programs, or we have programs and authorities that are mixed between the national, state, and the local governments. So in the past, it was clearly delineated, and now in the present, it seems to be all put together in a way that's kind of hard to extract what parts whose and whose parts what. But these are examples, visual examples to demonstrate, like, when you have clear delineation, you can have what we call cooperative federalism. And when you have mixed authorities and powers, that you have what we call the new federalism. So what are some examples of federal and state interaction? What I'd like to do is highlight the court systems in this example, or for this topic, because it helps to demonstrate to folks that the power that's shared. Obviously, we can look at how a president might interact with a specific governor on an issue. We can also look at how legislature, the U.S. Congress, will pass laws and how that might interact with state legislatures. But where we see kind of the clearest conflict or clearest examples of conflict is in the court systems. So here we have the U.S. federal court systems, and we'll go ahead and draw a couple of things here. And note that for the U.S. federal court system, we have the top level, which is the Supreme Court. And then we have the middle level, which are the appellate courts. And then we have the, call it the starter level. I don't want to call it the bottom level for the district courts. So as an example, you see this yellow shaded area, which I'll kind of circle in general. This is the Ninth Circuit of the Court of Appeals. And then within each state, there are district courts. So Montana has one district court. Washington has two. So let's call this the Western Court and the Eastern Court. Idaho has one. Oregon has one. California has 1, 2, 3, and 4 district courts. Arizona has 1, Nevada has 1, Alaska has 1, Hawaii has 1, and Guam has 1. So there are a number of district courts that are nested within this appellate court, and just see that the appellate courts are nested in this national geography, where we have not just the Ninth Circuit, but the 10th, the 8th, the 5th, and all the way down to the 1st. So we see that delineation of federal power or federal judicial power at these different levels. So the Supreme Court has, we'll call this here national jurisdiction. Appellate courts have, we'll call it specific geographic. And then district courts, we'll say, are nested in circuits or appeals geographies. So there's tension, right? These federal courts will hold each other accountable to some degree. The district courts will make a ruling. It can be appealed. So the ruling of the district court can functionally be overturned or overruled, and then that could be appealed to the Supreme Court, and the Supreme Court can either sustain the appeals court decision or to find in favor of the district court's ruling. Obviously, it's a little more complicated than that, but the point is that there's a tension of power within the federal courts. Now, here in California, we also have a court system, and we also have a state Supreme Court, Court of Appeals, and trial courts. So again, the Supreme Court would cover the entire state, so statewide. The appeals courts, there's 6 of them, and there's different districts. So we have the 1st district, 2nd district, 3rd, 4th, 5th, and 6th. And then we have trial or superior courts, which are also called county courts, and those are nested within counties. So like, for example, here in our home county of San Diego, this has a superior courts system. Now, again, someone can sue in a county court on an issue, maybe that's within state law or state constitutional questions. It can be appealed to an appellate district or an appellate court, and if the appellate court agrees with it, cannot, or regardless of the decision, it can be brought forward or requested to be brought forward to the state Supreme Court for make a broader ruling. So here again, you see this tension within the state court system of holding each level accountable to the laws and the procedures and the regulations and the processes that are in place for both the federal level and the state level. Now you might be asking, okay, so where's the interaction between the federal court system and the state court system. So let's go ahead and take a look at a couple of examples. The first one is a Supreme Court case called Jones versus Mississippi. And I'll go ahead and click on the link here, which will take us to a website called Oyez. Even though it's spelled O-Y-E-Z, the Z is silent. Oyez. I like to say Oyez, even though that's not correct. So it's Oyez. So this is Jones versus Mississippi. This was a argument made in 2020. The petitioner was Brett Jones and the respondent was Mississippi. And I'm going to go ahead and have the facts of the case read to us and then the question that the Supreme Court was asked to answer. So let's go ahead and highlight this so we read those things.
Facts of the case. When Brett Jones was 15 years old, he stabbed his grandfather to death. He was convicted of murder, and the Circuit Court of Lee County, Mississippi, imposed a mandatory sentence of life imprisonment, and Mississippi law made him ineligible for parole. The appellate court affirmed his conviction and sentence. In a post-conviction relief proceeding, the Supreme Court of Mississippi ordered that Jones be resentenced after a hearing to determine whether he was entitled to parole eligibility. Subsequently, the U.S. Supreme Court decided Miller v. Alabama, 567 U.S. 460, 2012, and Montgomery v. Louisiana, 577 U.S. __, 2016. In Miller, the court held that mandatory life in prison without the possibility of parole sentences for juveniles violated the Eighth Amendment's prohibition on cruel and unusual punishments. And in Montgomery, it clarified that Miller barred life without the possibility of parole for all but the rarest of juvenile offenders, those whose crimes reflect permanent incorrigibility. The Circuit Court held the hearing weighing the factors laid out in Miller and determined Jones was not entitled to parole eligibility. Question: does the Eighth Amendment require a sentencing authority to find that a juvenile is permanently incorrigible before it may impose a sentence of life without the possibility of parole?
So you hear the facts of this case where a minor murdered his grandfather and was sentenced to life in prison without the possibility of parole. And as there's changes in Supreme Court decisions, it opened up this space to ask the question that we see here: does the Eighth Amendment require, so the Eighth Amendment of the U.S. Constitution, does it require sentencing authority to find that a juvenile is permanently incorrigible before it may impose a sentence of life without the possibility of parole? Now you might be asking, what's this word? And I like to point out this is like one of the GRE words that you take or that you learn about. So an adjective is not able to be corrected, improved, or reformed, right? So they're basically saying, does the Eighth Amendment require a sentencing authority like a court system at the state level to find that a juvenile or a minor is permanently not correctable or not cannot be remedied before it imposes a sentence of life without the possibility of parole? Now you might be asking, okay, so where's the connection here? Well, this was a Supreme Court of the state of Mississippi Supreme Court made this decision, and then it was brought out of the state Supreme Court system in the state of Mississippi to the federal courts, and this was a question for the Supreme Court to the U.S. Supreme Court, the federal courts, to answer. And so the conclusion here at a 6-3 decision was that a sentencing authority need not find a juvenile as permanently incorrigible before imposing a sentence of life without the possibility of parole. So I'm gonna go ahead and have this read to us here.
A sentencing authority need not find a juvenile is permanently incorrigible before imposing a sentence of life without the possibility of parole. A discretionary sentencing system is both constitutionally necessary and constitutionally sufficient to impose a sentence of life without parole on a defendant who committed a homicide when they were under 18. Justice Brett Kavanaugh authored the 6-3 majority opinion. In Miller v. Alabama, 567 U.S. 460, 2012, the court held that a sentencer must follow a certain process, considering an offender's youth and attendant characteristics, before imposing a life without parole sentence. And in Montgomery v. Louisiana, 577 U.S. 190, 2016, the court stated that a finding of fact regarding a child's incorrigibility is not required. Taken together, these two cases refute Jones's argument that a finding of permanent incorrigibility is constitutionally necessary to impose a sentence of life without parole. The court noted that it expresses neither agreement nor disagreement with Jones's sentence, and its decision does not preclude states from imposing additional sentencing limits in cases involving juvenile commission of homicide. Justice Clarence Thomas authored an opinion concurring in the judgment, arguing that the court should have reached the same outcome by declaring that Montgomery was incorrectly decided. Justice Sonia Sotomayor authored a dissenting opinion, in which Justices Stephen Breyer and Elena Kagan joined. Justice Sotomayor argued that the majority effectively circumvents stare decisis by reading Miller to require only a discretionary sentencing procedure where youth is considered. Under Montgomery, sentencing discretion is necessary, but under Miller, it is not sufficient. Rather, a sentencer must actually make the judgment that the juvenile is one of those rare children for whom life without parole is a constitutionally permissible sentence. Further analysis.
So this is one example where the state courts make a decision and then it's appealed to the federal court system, and then the federal court weighs in with its decision. And this is one way of holding accountable, right? In this case, to state constitution and laws and regulations on sentencing of juveniles, and whether it's coherent with existing precedents and the U.S. this federal constitution and laws. Now let's give another example of this interaction between the state and the federal courts. I'm going to go ahead and open up this case, National Meat Association versus Harris. And I'll go ahead and have the facts of the case read to us.
Facts of the case. The National Meat Association contends that the Federal Meat Inspection Act prevents California from imposing its requirements on federally inspected slaughterhouses. In 2008, the state enacted the law after the Humane Society of the United States released a video of so-called downer cows being kicked, electrocuted, dragged with chains and rammed with a forklift at a slaughterhouse. The California law bans slaughterhouses from buying or selling downer cows and from butchering them for human consumption. The measure also requires humane handling of the animals. The U.S. Court of Appeals for the Ninth Circuit refused to grant a preliminary injunction blocking the law. Although the court said the humane handling provision probably was preempted by federal law, the three-judge panel declined to block it, saying the trade group hadn't shown its members would suffer irreparable injury. Question: is a California law requiring slaughterhouses to immediately euthanize any non-ambulatory animal on its premises preempted by the Federal Meat Inspection Act?
So there was a law passed, like a state law was passed by obviously the state legislature and signed into law by the state governor, and saying that if you have this type of cow, you can't treat any animal inhumanely, but if you have this type of cow, you can't slaughter it for human consumption. And so obviously slaughterhouses are not just regulated by state laws, or at least affected by state laws, but they're overseen by federal laws, and in this case, the Federal Meat Inspection Act. And so the slaughterhouses sued the state of California, saying that your state law actually shouldn't stand because there's a federal law that's would supersede or preempts your state law. And preemption means basically that the federal law is first and foremost, and that controls or should control the behavior in this case of a private sector slaughterhouse. So the question is for the court: is a California law, right, a state law requiring slaughterhouses to immediately euthanize any non-ambulatory animal on its premises preempted by the Federal Meat Inspection Act? So in this case, it was a unanimous decision, and we're going to go ahead and have this short paragraph read to us.
Yes. In a unanimous decision authored by Justice Elena Kagan, court reversed the lower court, holding that the Federal Meat Inspection Act's preemption clause applied broadly to any additional or different regulations a state imposes on slaughterhouses. The act prevails even where state law does not conflict with the federal act. The court rejected arguments that the act did not apply to animals rendered non-ambulatory before reaching the slaughterhouse. The court also held that the criminal penalties imposed by the state law were more than a mere incentive to improve humane animal slaughter practices.
And so here you see an example where the state, having its preference, passes a law, someone disagrees with that preference, and they won't go to the state courts to try to remedy it. In this case, they'll go to federal courts because there's federal law saying that, well, our law is first before the state law. And then here we find that the Supreme Court answered the question, is the California law requiring seller houses to immediately euthanize any non-ambulatory animal on its premises preempted by the Federal Meat Inspection Act? And the answer was yes, a strong yes, because it was unanimous across, in this case, both seniority and ideology with these members. So this is another example how the federal government, in this case, and its court systems were used to hold the state accountable to the federal standards that have already been established. So with that, we also have other examples that I'll just point out, like Medicaid. So Medicaid is a national health care program that serves people who are low income or of certain ages, in this case, the Child Health Insurance Plan or the Basic Health Program. And these are programs that were created at the national level, but they're administered at the state level. So how California and its state Department of Health and Human Services or equivalent, how it administers the Medicaid program will be a little bit different than how the Arizona State Department of Health or how the North Dakota Department of Health or the New York Department of Health would administer this federal program. So this is an example where you have the federal government saying, here's a program, here's standards, but the states are responsible for implementing it and how the states go about doing it. Say, for example, here in California, it goes from the state level to the local level. That's up to them. Obviously, there's rules and regulations in place but for the most part, this is an example of a delineation between the federal power and the state power. Another example are departments of transportations. So we have a national or the United States Department of Transportation, which is responsible for basically administering several trust funds that are funded by the gas tax, the federal gas tax, I should say, and other funding sources. And then here in California, we have the California Department of Transportation, which will go ahead and implement federal laws and at the same time implement state laws. And so what's fascinating about this dynamic in transportation or in the transportation field is that there is a delineation of responsibility between the federal government and the state government, but because of the growth in requirements and regulations by the federal government from things as now we would consider simple as seatbelt wearing to the quality of the infrastructure on interstate highways within the state boundaries, that there's a lot of interconnection between both the US DOT and the California DOT or what we call Caltrans. And so this is kind of a mixing of federalism because they're sharing responsibilities for the transportation systems. And then the last example is voting. So we have federal voting laws and organizations. So the one example is the Federal Elections Commission. This is an independent regulatory agency charged with administering and enforcing federal campaign finance laws. And the FEC has jurisdiction over financing of campaigns for the U.S. Senate, U.S. House, U.S. Senate, and the presidency and vice presidency. Now, at the state level, at least here in California, state election laws are administered by the California Secretary of State, and local election laws are administered by counties or cities. So, for example, say you're interested in running for a local office like County Board of Supervisors, you are under the jurisdiction of local county laws with respect to campaigning, and you're also under jurisdiction of state laws with respect to campaigning, but you're not under the jurisdiction of federal laws with respect to campaigning because you're not running for a federal office. So this is an example where you kind of have like a clear delineation of responsibilities. But say, for example, you go from running for a local level office to a federal level office, and then you're starting to see this interaction. So the simple way of thinking about it is you probably need a lawyer up, somebody who both knows local state laws and also federal laws. So with that, I'm going to go ahead and wrap up the presentation portion of it. I want to thank you for taking the time to listen in and just to kind of bring together or bring home the idea that when you think of the interaction between the state and the federal government, that it's very complex and it isn't just like, okay, one has one set of power and the other one doesn't. At this point, it's so mixed up that the courts are largely the venue to be able to say who's supposed to do what and how are they supposed to do it. And this interaction is just another way of how, in this case, governments try to hold each other accountable. So with that, thanks for listening in and have a good night.